All right, so our next topic is going to be this. You might be saying, what is that? Straw? No, well, here, let me help you out. It's this. What? Batman? We're talking about Batman. No, no, no. We're talking about, see, that's straw, that's hay. That's actually a bale of hay. We're going to talk about bale. And grander, in a grander sense, pre-trial procedure, which is essentially the stuff that happens to you, the police dealings with you, between your arrest and between your actual trial. Now, in order to understand some of the principles at play here, you have to understand that when a crime happens, right, the person isn't necessarily convicted right away. That's something that takes a while to get done. So you've got a scene where there's a whole bunch of things that have happened, and you might have a suspect who you think did it. And when you arrest that person, the way that you're going to deal with them is really going to depend on what kind of a person they are, right? If it's somebody like this, then you might deal with them in a way that's different than if they're some genteel person like in a murder mystery in those British towns where they're all in tuxedos and everything like that. Now, the whole idea that you're presumed innocent is kind of bent a little when you're dealing with the question of bail. Because, yeah, it's important to say that until we found somebody guilty in a criminal case, the accused is presumed innocent. We all believe that. It's in the charter. And you are innocent until proven guilty. And it is true that in the court, actually, judges, the police, everybody actually tends to treat you with a little more respect while you're still presumed to be innocent, even though everybody may think that you are guilty. But once you are found to be guilty, this presumption of innocence goes away. However, you'd assume as well, as long as I'm presumed innocent, shouldn't people treat me as they would an innocent person? The answer is kind of. Even though you're presumed innocent, that isn't actually a guarantee that they won't keep you in jail. Ideally, really, in principle, the police are supposed to release you after arresting you because you're presumed innocent. You haven't been found guilty of anything yet. They can't start punishing you when you haven't been found guilty. And depending on the case, they might do this by just releasing you right away after they've arrested you and stopped you from doing the thing that you weren't supposed to be doing. Or it could be that they'll bring you back to the police station to sign conditions of release. They might give you a form, something like this. This is a promise to appear. Or you could also see something similar, a citation to appear. And the way it looks, you see here, they would write your name and they would put your address and they'd say this is what you're accused of, according to whatever section of the criminal code or any other act. And you sign somewhere down here saying that I promise to attend court on a specific date. And this is really not fulfilling this promise is going to be a crime in itself. So they give you this, they let you go, and they say make sure you show up on this date at the court, and if you don't, you're in trouble. And then off you go. But it could be the case that instead of letting you go like this, the police, the prosecutor may decide that they'd rather keep you in jail until the trial. That may seem strange, but there are specific reasons why they might be allowed to do this. The prosecutor is going to try and convince the judge in a case like this that there is good reason to keep you, and the reason for doing this is going to be based on one or more of three principles set out in the criminal code in section 515 of the Canadian Criminal Code. Your lawyer, who's arguing your side, has a chance to try and convince the judge that based on those three principles you should be let out. But what they're arguing over are essentially three ideas. One, that it's necessary to keep you there, that the prosecutor's trying to show it's necessary to keep you in jail to make sure you show up in court because you might not do it if they let you go. They also want to show that it's important in order to protect the public that they hang on to you until your trial, because if you don't, you might go around bothering victims, witnesses in your trial, that you might actually commit more offenses between now and the trial. And so the prosecution tries to show, look, just to protect the public, we need to keep this guy in. And the third reason is a little harder to define. It's having to do with maintaining confidence in the administration of justice, given a number of factors, including the apparent strength of the case and how serious the offense is and the way that it happened. So prosecution argues these 3 points. Your defense lawyer tries to argue these 3 points in the opposite direction, showing like, yeah, you don't have to worry this guy's going to show up in court. Yeah, you don't have to worry the public's in no danger if this guy is out on the loose. And yeah, you don't have to worry people will respect the administration of justice even if this person is released until their court date.